consultations. A lot of them wanted a leader, a CJ who is a leader who is able to, to lead the over 4,000 judicial officers and staff, and also a leader who is going to lead that arm of government. So my question to you, Professor, is what unique leadership qualities will you bring as a CJ if you are successful?
I will start with the one that is immediately discernible, which is the fact that I would be able to be an intellectual leader. But beyond that, I am also a person who has extensive experience in leading diverse teams. I have been Dean of the School of Law, University of Nairobi, which is the largest law school in this country, for an aggregate of 5 years. I say aggregate because the first time I was the dean was in 2003, 2004, when students sent away the then dean, and it fell on me to lead the school. And that was a very difficult time because the students had actually locked out the dean. Then I was elected as dean between 2012 and 2016. Beyond that, I've also started a law school that is probably known to many of you, Strathmore Law School. And in starting the Strathmore Law School, I did the work of business planning, but also identifying the staff that were necessary. I have led institutions that are international. I've been an acting executive director of an international non-governmental organization, the African Center for Technology Studies. I have also established institutions. I'm not just a leader, I'm actually an institution builder. I actually build institutions that are fledgling, and the institutions that are not even there, I established, like Strathmore Law School. And if you look in the web, I started the International Environmental Law Research Center as a student at Stanford, which was to avail materials for students studying in Stanford who are not able to get resources. I've also established an organization, Women and Law in East Africa, and the Southern and Eastern African Research Center on women's law. I have chaired and also been a member of many boards, not just nationally. I've been a member of the International Development Law Organization Board. I've also chaired the Water Services Water Services Regulatory Board. I have chaired the Kenya School of Law Board. And actually, as dean, I chaired, I think for me, the most difficult board of more than 80 lawyers. So that would be where I'd stop, Chair.
Okay. So, Professor, my other question is, as you have explained, you are a great leader. You have done a lot of work, and especially in the academia and also public service, as you have explained. But from your CV, Prof, you haven't been a legal practitioner in terms of being either on the bar or on the bench. So, and please correct me if I'm wrong, but I would like you to convince the Commission and Kenyans that you are up to the task, even though you have not argued cases or written judgments. What do you say about that, Prof?
Thank you very much, Chair. I think in 2010, when Kenyans decided that they would open up the Supreme Court for academics, it was in realization that academics do bring in value to the bench. And the value that academics bring to the bench is a value that complements sitting judges and legal practitioners. And I should probably have said that practice of law is not really just about going to court. I probably have a lot more practice of law and practice within the judiciary because I have been engaged in a lot of judicial work. When the judiciary was getting birthed at 10, I was engaged to work on the Judiciary Performance Improvement Project, which actually has brought a lot of changes here. And that required me to have an in-depth understanding of these institutions. Beyond that, I have been a member of the Education Committee of the Judiciary, even before the Constitution, and was in the discussions that led to the establishment of the Judiciary Training Institute. I have also drafted and worked on curricula for the Judiciary Training Institute. And as a dean, when the late Justice Odek was the director, I spoke to him about us partnering so that the school could bring in a course on competition law. So one of the curricula that I worked on was on the commercial and financial law. I have also trained judges for many years, since 2006, when there wasn't much understanding of environmental law. I was engaged in training not just Kenyan judges, but also judges from East Africa, including Uganda and Tanzania. I should also say that because of another hat I wear, which is a chair of the Association of Environmental Law Lecturers in African Universities, an organization that has about 60 universities around Africa, I was asked to help African judiciaries come up with an organization like that. And I think this has now been established under the Southern African Judicial Education Institute. So, Chair, and maybe let me also say that as an academic, just going through different aspects of law, if that is not law practice, I don't know what it is, because you have to decipher the nuggets for the students. I do a lot of research. I am very widely published, and my publications are mainly on law and diverse areas of law. I have also drafted policies for the Kenya government. I mean, the biotechnology policy, 2006, the gender policy, 2019. I am currently completing the forest policy, and I've been engaged in wildlife policy. So I have a very deep understanding of the way in which law moves to become from policy to law to regulations to strategies.
Thank you, Professor. As I was doing my homework, Prof, and I'm sure you have done yours, I realized there's a Chief Justice who is a woman in Sudan, I think Ethiopia, Lesotho. So what kind of a CJ will you be as a woman CJ?
You know, when you get the position of leadership, many times you don't go there as a woman. Maybe I should say that I was the first woman law dean. And becoming a woman law dean people would have asked. Actually, many people came to discourage me, don't run for elections. And somebody told me, if they did what they did to the male deans, what are they going to do to you? I think leadership is not gendered. But I also think that men and women bring different values to leadership. There are things that women will do better than men, because probably they have the heart of the fact that you're a woman, a mother, a nurturer. That does bring some value when you come to the table. And I would say that I don't think that as a woman CJ, that should be problematic.
Okay. Lastly from me, Professor, there's one quality that some of the best leaders possess, and that is temperament. Mm-hmm. So I would like to know from you, Professor, what is this attribute, and and how will it help you as a leader?
You know, my temperament is calm. I can be calm under extreme temperatures, on a crucible, but calm. And that, I think, is a mien that is good for a judge, because you're going to hear many things, and you can't be expressing your facial expressions or your views just because people are throwing things at you. I would say I'm very calm. I'm not easily rattled.
Just coming back to your position as a leader and as a woman leader, have you faced the challenges and being the first dean, a lot of fasts? Have you faced the challenges either from just the public or people feeling this is a woman leader? And I'm saying that because even me, I'm one of them, Patricia and Professor, and I've come across that. Maybe you can explain to us.
I have faced some challenges. I think one of the one that comes to mind, which is comical, is going with my registrar to a meeting, and everybody was talking to him as the dean. And so I sat down and I said, you know, dean, then go right ahead. But it was comical. So he was able to tell them this is the dean. Because I am not huge of build, many people don't believe that Patricia Mbote is the woman that presents before them, because they think that you ought to have a little padding of flesh and also maybe a little taller, and then maybe the fast perceptions. The other thing that I have faced as a woman leader is that when people come to you, they expect you to treat them in a way that is less demanding of them. So when you demand of people, they're actually rattled. You know, when you take decisions that you need to take as a leader, there will be people, even young men, who will begin to throw mud at you, and you just have to stick with what you have to do.
Can you lastly give us one particular instant, Professor, that you can remember where you had to do exactly what you have said?
I remember being dean and having we had what were called University of Nairobi goons. That was in 2016. I had a very, very difficult body of students who would do just whatever they wanted. And I think one time they came and established a bar behind my office, and they were playing dombolo music when I was in the office. And then they also would ask other students when they had events to give them money. And I am a mother, so I know that these are students, they are people's children. So I called them and I told them, you know, this is not right. So they stopped the dombolo music, but what they did was to call, when students were reporting, they set up a table and collected money. And again, I called them and I told them, this is the second strike. Then there was Miss Parkland's campus, which was an event for students. And as I was trying to relax on a Friday afternoon, I'm told that the students are in danger because the male student, the goons, have struck. So what happened was that they continued like that. I would report, I had reports of them. Then the elections were held, and the elections were shambolic. The students were very, very unruly. So I knew that these young men were engaged. And so what I did was, through the processes, I wondered, were they going to be netted? And when they presented the list in Senate of who the students were, these students were not there. And so I actually told my boss, it is either these students are there or I am not the dean. Because you see, that also denies you the authority if people can get away with whatever they do. They went through disciplinary proceedings, and I must say I was sad myself at that process, because these were fourth-year students in the last 2 weeks. And I had not actually realized that if you put the university in an odious position, the only remedy, or the only thing that can be done to you is expulsion. And the students were expelled. So I actually later came back and have actually worked a lot with the university administrators trying to get these students back. And I do hope that they learned their lesson. It was a very painful lesson for me as a mother. When mothers come and lie on the seat in your office waiting for you to deal with them, and then you realize that these are very poor students, some of them. So that was one of the difficult things that I had to do.
Okay. So, Prof, just tell the Commission one or two things you have done, innovative things that have brought impact and which can be attributed to you as a leader because of your leadership excellence. And I know maybe you have talked about some of them, but just point out one or two that you feel, if it were not for my leadership as Professor Mbote, this would not have happened.
Okay, I'll give you two. One is the establishment of Strathmore Law School. And let me say that for me, establishing Strathmore Law School was a way of getting the giant in Nairobi to move, because I had been a leader there as chair of department, and I had vied for dean and not succeeded. And so when I was restless, and when the opportunity came for me to go and start a new law school, I felt like they had given me a blank sheet. Of course, I worked with very many people, but Strathmore gave me so much room and so much latitude that enabled me to start a school that I think is excellent. And the spin-off is that my school, my alma mater, University of Nairobi, woke up, because they realized that now there was competition in town. It was no longer enough to say we are old and we are gold. The new ones can actually, they can actually threaten your continuation. The second one I'll give is from this COVID-19 situation. In conjunction with the African Development Bank and colleagues at the school, we were tasked to train Kenyan and Ugandan lawyers on integrating environmental issues in oil and gas contracts. And we talked, in fact, the officials from the African Development Bank even came to visit us at the university. We were going to have it at the university towers. The students were, the lawyers were going to stay at the Norfolk. And we had the last meeting at the end of February. Then COVID struck. When COVID struck, I had three options as the leader. One was to call off the training and then say, we will do it another time. The second one was to wait out COVID, because now there were the travel bans. But I took the third one, which was to innovate. And I spoke to my younger colleagues, and we agreed that we were going to have training for Ugandan and Kenyan lawyers virtually. And so what we did was to get another group of young Kenyans. Kenyans, we have extremely talented Kenyans. I just told them this is what we want, a bespoke training platform, which would be used simultaneously in Uganda and in Kenya, and also would be accessible to the bank officials in Abidjan. And they did that, and we were able in June last year to host a 4-week program. What we had to do, of course, is to reduce the number of participants, because when you go virtual, then to engage people one-on-one, you need to have less students. And it went very well. Everything was done virtually. Even the certification was done using the bespoke system we had developed.
Thank you very much. I'll now request the acting CJ to ask you further questions.
Thank you. Professor, Senior Counsel, you come into an institution that has been doing something called transformation, more specifically since 2011. Okay. Please explain to us what prepares you for that transformation, whether you know what it is we want to transform ourselves from to, and what tools you would use in that transformation, or has that transformation in fact done time, and should we now go to something else? That will be my first question.
Thank you very much. It is interesting because I was in the first team who worked on the judiciary transformation framework. And you know, we were coming from the previous constitutional dispensation where there were very, very many problems in the judiciary. I must say that I have followed what happened with the judiciary transformation framework. I've also followed what you lead, which is the sustaining judicial transformation. And I can see a lot of steps have been made. I think we were talking then about a lot of backlog. We were talking about an under-resourced institution. We were talking about not integrating ICT across different spaces. I think, if I remember right, there was also discussions about accountability, the whole question of performance management, because this had become part of the public service with the NAC government in 2003. And I think for the judiciary, this remained something that was being talked about. And I would say that a lot has been done. A lot has happened since then. You know, even this Judicial Service Commission was not this kind of Judicial Service Commission. It was a different kind. And so a lot of things have happened. So you've asked me whether the transformation has done its time. And maybe I'm going to be a little controversial. I will say you can't be transforming for 10 years. It is too long. I think you have to stop and ask yourself, what have we done and what haven't we done? And in coming to this space, I come again looking at what has been done, but looking also asking ourselves, how are we doing? Because if you don't look at where you're coming from, you could actually go back there without knowing. My analogy, again, as a mother, is of a child who is 10. This is a judiciary under the 2010 Constitution. It is 10 years. A 10-year-old child is heading to adolescence. Adolescence can be very turbulent years, and those are the years that determine whether the child becomes a well-adjusted teenager or a maladjusted teenager. And it would be good to take stock and to begin to look at what changes have worked. How do we make that change stick?
Let us, Professor Senior Counsel, redirect our mind to this aspect, okay? We've been doing this for that period. Do you know the successes we have made? Professor Senior Counsel, I just heard you say that our initial problems were backlog, under resourced. Those were your words?
Yeah.
And of course, accountability. I have no issues with accountability. I would like you, with your own statement, to tell us whether then we actually need to move to the next level. And for you to fully answer that concern, do you know what our management culture has been? And do you know what it has contributed to being where we are at today?
I would be lying if I said I know exactly your management culture, because if you're not wearing the shoes, it is difficult to know how the culture works. I can only talk about it as an outsider and as a person who's been observing what has been happening. I think a lot of, I hope I didn't come out as saying that transformation didn't achieve anything, because the performance management and measurement understandings have actually movement towards some of the things that needed to be dealt with, but also the whole issue of active case management using the daily court returns. That has also helped because, you know, when a judge or judicial officer is now asked to account for how they've been using their time. I only know the judiciary before 2010 because I did very incisive research on it. This one I have interacted with, but a lot at a distance. And you see, when I would go to, I served for 3 years as the rapporteur of the Judicial Colloquia, and I have not served since 2011. So I really do not have that inning on what has happened.
Thank you, thank you. There is such a thing as looking into the inside from the outside. And since you are involved in JTF, and we have said one or two things about SJT, I would like you to address this concern. The PMMUs, the performance contracting that we do here, we don't call it contracting. I want you to tell us what it is we do there. Is that an achievement? Has it actually changed anything? Has it interfered with the judicial independence of judicial officers? Is it a matter that goes to accountability? And as you answer that, Professor Senior Counsel, I want you to relate it to a statement you made earlier and said, when you failed in your attempt to be dean, you became restless and therefore went to Strathmore, and now you're back at UON. Could you relate that to transformation? Then we will move from that topic.
I understand the question to be how the steps that have been taken in the judiciary have impacted on the working of the judiciary. And I think you're taking this from the core of what the judiciary is about, the fact that you need to have an independent judiciary. And therefore, even as we talk about the performance management and measurement understandings, it is important to still bear in mind the importance of judicial independence, both for individual judges, but also for the institution. And I think the fact that there are different levels that have been established, especially under the acts that were passed after 2010, and also under the SJT and JTF, there are different levels of accountability. And I would say that these things go to the heart of independence. You can't look at independence without looking at accountability. And I think for the judiciary, because it is a counter-majoritarian institution, the judges are not voted for, it is important for the judiciary to actually show how accountable it is to the Kenyan. Why should Kenyans invest in the judiciary? And I think the way that is demonstrated is through what we put in place for accountability. And that can be internal or external, and PMMUs and other mechanisms are the internal ones. But there is also something I shouldn't fail to talk about, the code of conduct. Because you see, with a code of conduct that judges are aware of, then you know what are the permissible and not permissible actions.
As we leave that topic, Senior Counsel Professor, would you like to say something about your being restless?
I was young and restless then. I was in my 40s. I am now headed to 60. You know, there's something that comes with growing old, that you begin to see what it is that you need to do. If I was to make the decision of starting a new law school, I would do the same. And actually, even in leaving, though I said I was restless, I was within my rights to leave. You can take unpaid leave from the university and go and do something. What I did was unusual. Starting competition was not usual. So, Chief Justice, I have become a lot more less restless.
I hear you. In fact, the reason I ask is because of the step you took next, which was to be very successful at starting the law school at Strathmore, waking up the giant that was the UN law school, and then going back to the UN. Why?
Why did I go back?
Yes, yes. You have gotten to Strathmore. You're successful at Strathmore. Why then go back? And how did you go back?
You know, I live by two mantras. One is Franz Kafka's mantra that paths are made by walking. So there doesn't have to be a road for me to take it. And when I went to Strathmore, I talked a lot to my younger colleagues, and I was telling them, you know, build the field, the players will come. But I also live by another mantra, which is by Woodrow Wilson, that we are not here merely to make money. We are here to make a difference. And when I started Strathmore, Strathmore is a small school. And I felt that there was a lot more that I could do at the University of Nairobi. Also, because it was a private school, the kind of students I'd meet there are not like the kind of students that I had met at the University of Nairobi, who are actually from all corners of the world. You know, people who came to Nairobi for the first time. And so to make a difference, I thought that going back to the University of Nairobi was it. But I still mentor Stanford scholars. When they call on me, I go to them. And it's not just Stanford, I mean Strathmore. It's also other schools.
All right. Thank you, Professor, Senior Counsel. Let's go to my next assigned area of discussion. Senior Counsel, when you come here, you become the president of the Supreme Court. We'll discuss that a little later. For now, I want us to discuss the chair of the Judicial Service Commission. What do you see as your roles there, and what would be the first thing you would fix once you get to the chair, Judicial Service Commission?
As chair of Judicial Service Commission, I think there is something that I have noted as both as a scholar and also as a Kenyan. And I think this is the fact that the Judicial Service Commission is very underfunded, and they are responsible for judicial training. As looking at the budget, and I think it is the total budget, if I'm not wrong, is $500 million. But the needs of training are a lot. I would actually bring in training, and I know that we are operating in a very constrained resource space. But as a Chief Justice and the chair of the Judicial Service Commission, I would leverage networks. Like, you know, I'm coming from a school, so my colleagues should be able to teach judicial officers, those who don't go to court, without pay. And I also have networks around the world. I would be able to leverage those to bring up the teaching.
What is the core mandate of the Judicial Service Commission?
They are the employer of the judicial officers. That's what I think they are.
All right. And then you are your leadership, the Chief Justice of the Republic of Kenya, okay? And you have all these many stakeholders. I want us to deal with the internal stakeholders. What do you do there, and how do you ensure that you are successful?
You know, if you get into an institution and you're not accepted by the stakeholders, then you're going to not succeed. And I think even though I would have my ideas about what I bring into the judiciary, I would actually want to understand the culture that is in the judiciary. And one of the things I would actually do, I mean, I would like to work with a serving judicial officer, I say my chief of staff, because they will guide me through the hoops. Because if you get an outsider and you're an outsider, you really don't know what's happening within the institution. I've found out as a leader, there is nothing like knowing the pulse of your organization. And I would aspire to know the pulse of my organization.
So you would go for a chief of staff that was internal. I hear that. Let's go to the next role of the CJ. Now, that Chief Justice is of necessity the chair of NCAJ. Kenya law is the link between the judiciary, he, she, I mean, we know what he means in the Constitution, is the link between the judiciary and the other two arms of government, amongst many other roles. I'm leaving the role of Chief Justice as President because I want us to discuss that at a bit of length. So please tell us what prepares you for the balancing act that of necessity is required to be a successful Chief Justice, to be a successful Chair JSC, successful Chair NCAJ, Kenya law, and the link between ourselves, the other arms of government, and the world at large. With that answer, we shall then go to something else.
Okay. What prepares me to serve as chair, I think I did say that I have served as chair of many boards, Water Services Regulatory Board, Kenya School of Law. And I was actually also a member of the National Council for Law Reporting as Dean of the School of Law, University of Nairobi. And so I could see and I observed the way in which law reporting is actually such a critical aspect of the judiciary that the Chief Justice was able to guide what is happening. So in essence, the chairing, I have experience doing that. I think as Chief Justice, being Dean, I was also the intellectual and administrative head of my institution. And you see, if you're a dean of very senior professors and you don't command the respect through the work that you do, then you see they won't respect you. And then when it came to administration, I needed to be the person between the school and the main university, because we are only a small unit. There is a college, and then there is the main administration. So I would say that I developed ways of navigating those relationships. With the executive and other arms of government, I have worked with different arms of government, and of course not as Chief Justice. And I think diplomacy and negotiation are ways in which one could actually work with these institutions. I don't know whether I'm answering your question, but Chief Justice, because you are my senior in school, if there is anything I don't know and you're here, I will learn from you.
Thank you, Professor Senior Counsel. And now you are Senior Counsel, I am not. Let's go to the other area that is my leading area. Please tell us the principal in Mulberry and Madison, and tell us how it impacted, if at all it did, the 2010 Constitution, what it does to constitutional democracy, what it does to the judiciary when it relates to other state organs, and please cite, if you may, any recent cases that derive from that principle.
Thank you very much. It's a long time since I read Marbury versus Madison, so I would say that I haven't interacted with the ratio decidendi, but in terms of constitutional democracy, I remember vaguely about the separation of powers. And in essence, what the 2010 Constitution did was to make the judiciary a lot more independent. I think in previous constitutional dispensations, the judiciary was subservient. It was almost subservient to, especially the executive. If you look at the way in which judicial staff were hired. So I would say that it has helped clarify the relationships. In terms, the case that comes to my mind is actually a case that is alive in court, that I would not want to talk about here.
No, you wouldn't. You would not do that, at least not rightly. I was talking about already decided cases, but let's leave that for a minute and deal with the scope of judicial review. Do you want to say anything about the scope?
Yes, I'd like to say something. I think judicial review before was really based on common law, and I think the Article 47 constitutional provision on fair administrative action has first of all constitutionalized judicial review, but also expanded the scope because fair administrative action is required of not just state organs, but also non-state organs.
Please listen to this. This one I've written out because I want us to help the Commission to arrive at the right decision, and two, to help the court that you are coming to be president of. Okay? Some have indicted the Supreme Court, and particularly its position on the interpretation of the Constitution. There's been quite a bit of indictment out there. For you to answer that question, please tell us what the stated objectives in regard to constitutional interpretation there are for the Supreme Court, and how you think that, what techniques you think ought to be applied, and as this current Supreme Court done that, ought to be applied, or what you would yourself require of the rest of the 6 of us to apply to coherently achieve the objectives of the court as regards interpretation and to serve the people of Kenya who pay our salaries.
Okay. The Supreme Court, you say, has been indicted. I think the indictment sometimes is unfair because this is a young court. And there, as a new court, as you get things put in place, there are different things that need to be refined over time. I think if you look at, there are things that the Supreme Court has guided and guided well. If you look at the advisory opinion in the National Land Commission, it actually quelled the differences between the Ministry of Lands and the National Land Commission because they were in the papers every day. And I think also, to give a second example, when you look at the digital migration, you know they forced the action of digital migration. So I think in that way they have moved us ahead. So in terms of exercising jurisdiction as a court and what principles guide, I think Article 259 of the Constitution talks about interpreting the Constitution with the values, the principles that are in the Constitution to ensure respect for human rights, respect for fundamental rights, good governance. And I also like the statement that the Constitution is always speaking. So when you are a Supreme Court judge and the Constitution is always speaking, then it means that you have a very big responsibility to ensure that how it speaks is going to guide and move jurisprudence forward. Yeah, jurisprudence forward. I think this whole issue of whether the Supreme Court, what kinds of techniques it can use, it has begun to use them. You know, when it decides what is a matter of public interest that should be admitted into the court. Granted, there may have been opening up of issues that should not have been opened up, but when you look, all the time you are talking about good faith, that they acted in good faith. So it is not, if anything happened, they were seeking to abide by the principle that you must avail justice.
All right. Thank you, Professor. Let's go to, so as to finish on that topic. We are required by the Supreme Court and the judiciary at large is required by our current strategic plan and by, to a great extent, the Constitution itself, to develop something called indigenous jurisprudence. Please tell us what that is, and tell us what you have found to be non-indigenous jurisprudence from the court. And as you answer that question, because that is the last one I ask on that area before my next final questions under the court, there's something around this area called hierarchy. It is a statutory requirement. Tell us what that is, tell us its challenges, and tell us the opportunities it creates.
I think when the 2010 Constitution was passed, the interest and importance of ensuring indigenous jurisprudence was speaking about decolonizing our legal system. And we were at a place where we were deferring a lot to authorities, and also even definition of terms from outside, which probably did not make a lot of sense to the local people. I remember in the early days of the judiciary, it was being talked about as Wanjiko. And you see, if we are talking about Wanjiko, there is need to make the jurisprudence that is coming out there address Wanjiko's issues. And I could go on a lot on that, but if
All right.
that satisfies
Yes,
you.
yes, it
But
does.
hierarchy, hierarchy, when you talked about hierarchy, what came to my mind was the hierarchy in the legal profession, the hierarchy in the court, but hierarchy of laws. I think that's what you're talking about.
Both.
So the hierarchy of laws, we have a very uncomfortable situation where, because of introduction of British law, a lot of our local laws were actually muted, and many of them really were not given an opportunity to develop. So when you talk about hierarchy, and then we say that we had under the Judicature Act the whole question of what is repugnant to justice and morality. I mean, for me, and I think I have written on this, whose justice, whose morality? So as we talk about hierarchy, and when we look at different issues, if we are not careful, it is likely that you can actually have a justice that is removed from the people, because the Constitution is the premier. It's actually it's the top it's the top legal norm. But under the Constitution, there is already what shall I call it? There is a contradiction or a paradox, because the Constitution admits other laws as long as they abide with the constitutional provisions. And this is not a very easy distillation to make.
Thank you, Professor. Let's get to the court in which you have exclusive jurisdiction. And it is the Supreme Court, and you find when you arrive in June that you have 6 judges below you. In that time, you will no longer be my schoolmate, you will no longer be my lecturer, you will be the first, which is something you mentioned earlier, among equals. Some of those judges started the court in 2011. The rest of them have been there a minimum of 5 years now. And so, surely they have something you don't have. Please tell me how you would deal with that. And at the end of your answer, please tell me something about building collegiality, and what collegiality in truth is. And finally, on the same issue, because this is judgment making, you said at the university, the people you called goons, I don't know whether they were university students or externals, but those goons led to some people being expelled at your instigation. Shortly thereafter, you came back and said, pleaded for them to be readmitted. Please tell us what that does to judgment making. And that would be the last question in that area.
Okay. I recognize that a lot of the people who are serving on the Supreme Court have a lot of experience. I am not the kind of person who comes in that because I am the Chief Justice, then my word is final. So there is going to be a lot of discussions as we make decisions. And there's going to be a lot of, I think, just encouraging people to openly air what their views are, which goes to the issue of collegiality. You know, collegiality is something that you can't force through law. So it is very important, and I hope it happens at the Supreme Court, that you have bonding sessions where people are able to know what is it that makes the other person, what makes the other person tick, and why do they behave the way they do. You know, collegiality is about companionship, is about empathy with the other person's views, but at the end of the day, a decision has to be made. So if a decision is being made that is against what a person has said, then I think the issue that comes against collegiality is civility. That whatever, even if you disagree, you do it in a way that does not dehumanize or make the other person feel that they are lesser than yourself. I think a way of building this is also encouraging the judges of the Supreme Court to exercise their mind and use their pen. I think it is, when you work in groups, there will always be a dominant person. And I do know that I can be a dominant person. So that I'm very aware of. I let other people do what they have to do, and I bring my issue along others to avoid being dictatorial, and to avoid asking people, I mean, or doing things that have no collective agreement. The other one that you...
The goons?
The goons.
And judgment making.
The goons and judgment making. You know, thankfully, the rules of the university have changed. So probably nobody will have to sit on that kind of moral issue. But I think the Supreme Court decision binds all courts. But it does not bind the Supreme Court. And you know, I'm using this in a very loose sense because the Supreme Court cannot sit on appeal on its own decisions, and that is going to bind me should I succeed in becoming the Chief Justice. But on the other hand, even should there be need to change, that change is actually in exceptional circumstances. So what I'd say is the goon situation is a simple situation compared to what you face in the Supreme Court.
Finally, that court as original jurisdiction in at least 3 instances. What are the 3 instances where the court of which you would be president that has original jurisdiction? How is it exercised? And because that's a wide question,